Thank you all for joining us today. We are going to have a great employment law CLE webinar. Our presenter, Victoria Guzman, is happy to take questions in real time via the chat, or if you want to unmute themselves, there will be a portion of time at the end of the presentation to ask questions. We can moderate that way. So if something pops up that you really, really want to ask about, Victoria's fine if you want to chime in really quick. But otherwise, again, we'll get started. This recording will be available on our YouTube channel. So if there's anything you want to revisit, you'll be more than able to do so. I'll get the CLE and the PowerPoint from Victoria and get that out to you hopefully later this afternoon or tomorrow at the latest. But for now, I will go on mute and thank Victoria Guzman of the Wilhite Law Firm for presenting today. Victoria?
Good afternoon, everybody. I'm going to go ahead and share my screen real quick. Okay, so I'm not sure how many of you practice in the wage and hour area, but my practice primarily consists of representing low wage workers in individual cases and class actions, and primarily just under Colorado wage and hour law. We occasionally branch out into cases under the FLSA or the Fair Labor Standards Act, but there's a lot of meat in Colorado wage and hour law, and there's a lot of good work that can be done in this area. And so I'll just give you some primary updates and then some things that have developed in the last year or so and things that have changed in some recent cases that have been flagged as some key changes or things to pay attention to. So we'll go over the statutory changes, changes with the division. That's the Colorado Department of Labor and Employment, the Division of Labor Standards and Statistics. They've been in recent years been doing some great work and making some drastic changes to Colorado law. Recent cases that came out from the Colorado Court of Appeals and the Colorado Supreme Court, and some other ones, and then some other cases that are not quite so new, but I'm finding are still being argued and have some key importance to litigating in this area today. So some of the key statutory changes effective this year, Colorado minimum wage went up to $14.42 with the tip credit. That's $11.40 an hour. The tip credit is an employer can take up to $3.02 toward their obligation to pay an employee's base wages. That is, the employer doesn't have to pay the full minimum wage. They can pay just $11.40 an hour to comply with Colorado minimum wage for tipped employees. And tipped employees are people who make $30 an hour, or not, sorry, apologies, $30 a month in tips under the statute and under the Wage Act. And in Denver, the minimum wage is $18.29 with a tipped minimum wage of $15.27. That tip credit can only be used by employers who operate in a restaurant or bar area, whereas the full Colorado minimum wage, the tip credit can be applied to any employee who receives tips. Denver limits the tip credit to employers in the food and beverage industry. And the Denver minimum wage applies to workers who work in Denver City and County at least 4 hours in a week consecutively. It doesn't apply to employees who are just traveling through, but if an employee is sent to work in Denver for at least 4 hours, then they are entitled to that increased minimum wage. The Denver Revised Municipal Code provides for some great teeth to employment actions. There's travel damages, penalties of $50 a day for every day that the violation occurs, as well as 12% interest, attorney's fees and costs. And so Denver has made it very clear that they are serious about wage violations. And in addition to the minimum wage going up this year, Denver has expanded its revised municipal code to applying to all earned wages. So under the Colorado Wage Act, if you have an agreement that you should pay an employee a certain hourly rate and you fail to do so under Colorado law, you have a claim. And Denver has now declared that it wants its employees to have that same right in Denver with the additional penalty provisions under the Denver Revised Municipal Code. This year, Edgewater, additionally, that's the city that's just outside the edge of Denver, has declared that it wants its own minimum wage above Colorado minimum wage. It's $15.02 an hour with the tip credit, minimum wage of $12. Apologies if you can hear my cat. I am working at home and she does not like it when she's not getting attention. But Edgewater has essentially attempted to mirror Denver's revised municipal code. They, in their opening act or proclamation, has declared that they want to bridge the gap between Colorado minimum wage and Denver minimum wage. And so they're essentially trying to follow Denver's revised municipal code along with those treble damages, the penalties, the increased interest and attorney's fees. So Edgewater also has some great teeth. I mean, it's only a few block radius, but for those employees, there are now some additional protections. Most importantly for you at the Boulder County Bar Association, Boulder County has also incorporated a new minimum wage that's above the Colorado minimum wage effective this year. It's $15.69 an hour with $12.67 with the tip credit. Again, that only applies to employers who are working in the food and beverage industry. However, Boulder County's is only for the unincorporated cities within Boulder County. So it does not apply to Boulder City proper, and it does not apply to any other incorporated city or municipality within Boulder County. And we'll get a little bit more into that. It primarily only applies to a few of the smaller mountain towns. One other thing that came into effect this year is that family has been extended to private sector employees. Previously, family applied last year to public sector employers, and now it has been fully expanded. It is a state-sponsored family medical leave program that is meant to mirror the FMLA. However, it applies for some sort of paid leave for employees. And so the FMLA is job protection for employees who have to take qualifying leave for care of themselves, care of a family member, for a qualifying medical reason. And family now provides for a way for employees to get paid at a portion of what their salary rate is in order to take that time and not have to choose between spending time with a new child or caring for themselves or a family member after a major surgery and still having some form of income. There's no specific obligation on an employer other than to notify employees upon hire and of an FMLA event. That's the employees have been getting taxed through family for the last year or so in order for the state to fund this leave. But an employer is prohibited from retaliating against employees for taking family-related leave, and there are private cause of action if an employer retaliates against an employee for taking that leave. Employees apply through the state division that has been created to enforce family in order to take that leave. And so it's just something to be aware of, as if an employer fails to notify or if an employer retaliates against an employee for taking that leave, there is potential recourse for that employee. There has been some additional statutory changes during 2023 that I would like to flag. I previously mentioned the Colorado Wage Act. That is the primary act in Colorado that provides for employee protections. It requires employers to pay wages within a certain time, prohibits employers from taking deductions from wages, declares that tips are the property of employees and not the employer, and sets out timelines for when an employer must pay their employee when they leave employment, are terminated, make a written demand for unpaid wages, and provides for expansive penalty provisions. Last year on January 1st, the penalties, automatic penalties, were 125% of the first 50% of the wages owed, or the first $7,500 owed, and then it was 50% on the remaining wages owed. Now penalties effective last January it's either $2,000 automatically or 2 times the amount that's owed if an employer fails to pay those owed wages within 14 days of a written demand. A written demand can be a text message from the employee saying, hey, you didn't pay me my wages for my final week. It could be an email to the HR saying I didn't get my PTO, or this information is missing from my latest pay. And so now the Wage Act has drastically increased the potential penalties that an employee can see. In addition, the willfulness penalties have increased to an additional $1,000 or an additional 1 times the amount owed. So if an employee is owed $5,000, they have a potential $20,000 case if their employer fails to pay within 14 days of a written demand, and you can show that that denial of pay was willful. And so there's much more teeth to it. Additionally, the CDLE, the Division of Labor Standards and Statistics, is now authorized to register judgments with the court. Previously, the CDLE and always employees were able to file claims for unpaid wages through the CDLE to investigate and issue a determination up to $7,500 of wages. However, when the CDLE issued a determination and the employer just didn't respond or didn't pay, employees were left with no recourse other than to figure out how to register their judgment with the court, hire an attorney to attempt to collect on those wages. Now the CDLE is empowered to automatically register those judgments with the court so that the employee has a registered judgment and not just a piece of paper that says they're owed money. And they can use that judgment to attempt to collect on those judgments. And the CDLE is, I'm aware they're automatically registering those judgments, and they'll provide the employees with a copy of the court order once it has been issued. And I believe they're able to take some steps to collect on those judgments, but I'm not sure what steps they're taking at this point, since it's still relatively a new power that they have. Another area is HIFWA, or the Healthy Families and Workplaces Act. This was, for those of you who do not know, it was enacted during a peak of COVID in July of 2020 in order to provide for paid leave for qualifying events, for leave such as if you're injured or you're sick or your child's school closes or your work closes due to COVID, or if you are a victim of domestic abuse and you need to seek care. It's pretty expansive, and it also applied public health emergency leave when there was a public health emergency declared by state, local, or federal government. COVID qualified, and that provided for additional 80 hours of leave in addition to the accrued leave that employees were entitled to under the regular provisions of the Healthy Families and Workplaces Act. That entitlement to the additional 80 hours of leave expired on June 8th. The federal, state, and local governments in Colorado declared that COVID was no longer a public health emergency sometime in May, and on June 8th, the extension of that leave expired. However, on August 7th, HIFWA was expanded to require employers to provide accrued leave for bereavement leave and leave due to inclement weather or power, heat, water loss, or other unexpected events. Employers are required to accrue leave for the employees for every 30 hours worked, up to 48 hours each year. And an employer cannot deny paid leave for any of the qualifying reasons listed under Section 404 and up to and including bereavement leave for family members, and leave due to inclement weather, such as perhaps the polar vortex that we had last week. I haven't seen any claims for that yet, but I imagine that that would likely qualify. And then, so there are, I had mentioned the division earlier, the division, beginning in 2020, the division issued the Colorado Overtime and Minimum Pay Standards Order. It made drastic changes to the previous minimum wage orders by getting rid of, there were previous, you must have had to work in one of 4 industries to be covered by the minimum wage, overtime, meal and rest break protections under the minimum wage order. Those 4 industry categories were a little vague and hard to understand, and the division introduced through rulemaking and public comment the Colorado Overtime and Minimum Pay Standards Order, and it came into effect on March 16th of 2020. It got rid of the industry categories and presumptively included all Colorado employees unless they were specifically excluded for the type of work that they were doing or by industry. And there have been changes to that order with each year. And so it's important to keep up to date on that order, but it does provide some drastic and more protections for those employees. And along with the comps order, the division began issuing infos. It's an abbreviation for interpretive notice of formal opinion, I believe. Don't quote me on that, but I think that's what the full name of info is. The infos are intended to be documents, like the short 3 to 4 page documents that a lay person can refer to, an employer can refer to, an attorney can refer to have additional explanation for the proper interpretation of Colorado law. And the infos are meant to are designed to have Skidmore deference. I believe that the actual full name of the info hits all of the different check boxes for determining whether or not a document from an administrative agency should have Skidmore deference. They are the brainchild of Scott Moss, who was a former professor at CU Law and switched over to being the division director at the CDLE. They have been very useful for employee and employers in practice. I have seen opposing counsel issue infos in discovery responses, and they have been great for citing in case law. We have had some success in having judges interpret the infos and use those infos to give them deference to make our arguments. And I know that the division is eager for attorneys to use them in litigation, just because the division really thinks out how they are using what they're stating in these infos with great citations to your arguments and explanations to how the law should be interpreted. And the division is constantly updating the infos as the law adapts and as develops are made in wage and hour law and in other areas that the division is responsible for overseeing. Up here, I have flagged some of the key infos that I have seen changes to in 2023. The tips info number 3C. In that info, the division declared that if there was a charge that is mandatory, it is not a tip. And so it does not belong to the employee, and the employer can use it as any sort of income that they have. But if the employer communicates to the public that the charge goes to the employee, it then becomes wages and compensation that the employer cannot deny the employee or use to partially put in their own pocket to subsidize their costs. Previously, tips were not and continue to not be very well defined in Colorado law. And so in response to a lot of restaurants, particularly issuing these mandatory 20% or 22% or whatever percent service charge, there has been a lot of confusion about, is that a tip? Is that a wage? What between both consumers and employers and employees about who that money belongs to. And so the division issued info 3C in, I believe, July of 2023 to declare the differences between what those mandatory charges look like and what an employer is permitted to do with them. Additionally, in the fall, the division issued a worker classification info that sets out the factors to be considered in determining employee status. We see a lot of employees who are labeled as 1099 workers, but who operate and function as a W-2 worker. And that classification has a multi-factored prong test that you must look to see at the realities of the relationship between the worker and the employer. And this info sets out those factors that can be determined and sets out some case law that can be cited to when making those determinations. So it's really helpful as a reference sheet when you're looking to see if somebody is improperly classified or properly classified, and provides for sources of citation when in your legal arguments to the court. The time worked info, there are, I just flagged number 20B. However, there's A through C that sets out the various descriptions of what time an employee should be compensated for. I specifically flagged 20B because it sets out that minimum wage includes overtime. That has been unclear in the past, and it explained that an employee is entitled to, say, if they work 40 hours, they're entitled at bare minimum to minimum wage during that year for 40 hours. But if they work 60 hours, they're not entitled to just say, in 2020, the minimum wage was $12 an hour. They're not entitled to just $12 an hour for those 60 hours. They're entitled to $12 an hour for the first 60 hours, and then an additional $6 an hour for those 20 hours that went over the 40. And so that has been, having that clarification is very useful for employers and employees, and my firm has successfully cited it in case law to argue that an employee is entitled to additional minimum wage for those overtime hours worked, and not just the bare minimum wage for the first 40 hours worked as applied to all hours worked over 40. The enforcement info, number 2D. I was mentioning earlier how the division, as of January 1st of 2021, was entitled and gained the power to register their judgments and decisions with the court. And Info 2D explains their efforts and what steps they'll take. So they're very helpful primarily for the employees who filed cases with the CDLE and they're not sure what steps to take from there. That info sets out exactly what they should be doing, what if there's anything that they need to do, and what to expect essentially when they've received a determination from the CDLE, but they haven't received any payment from their employer. So it's just a really good resource for potential clients who reach out asking for assistance, and this essentially explains what recourse and what resources that they have. And then finally, at the bottom, I flagged the local government authority to set local minimum wage, or info number 19. That explains explicitly for all of you, which unincorporated municipalities within Boulder County that the new Boulder County minimum wage applies to. It's a full analysis of all of the various minimum wages throughout Colorado, and sets out what they were previously, what they might be going forward if known, and explains to which employees, which employers they apply to. And it's a very helpful quick reference sheet for determining if a potential client is owed minimum wage under one of the various local government municipal codes. And I have applied, let's see if this works. I did not test this, but it's going to reshare my screen so that you can see. I have linked to the Colorado Bar Association, or not Colorado Bar, apologies, the Colorado Department of Labor and Employment's website. You can see on here that it sets out on its main page the annual minimum wage for Colorado, Denver, Edgewater, and Boulder, and the previous minimum wages for the last recent years. But under frequently used resources, you can find the link to all of the infos that are referenced and used within the division. I only flagged a few that I have noticed the division issued key changes to in 2023. But as you can see, the division is constantly updating these infos, and there's infos on a wide variety of topics that may be useful for your practice. They start out just the basics of commissions and bonuses, and they're constantly updating them whenever the various laws that they enforce change. You can see on here, there's an info for FEW, or the Protected Health, Safety, Expression, and Whistleblowing Law. It hasn't been updated, but there haven't been too many changes to that law. So there hasn't really been need to update it, but they have the most recent infos on their website in PDF form available for you to use. They have some of them in Spanish for your clients if they need. I believe they have all of their agricultural infos in Spanish because a majority of those workers tend to be Spanish speaking. There are some of the more main infos that are in Spanish, and I believe they're working on getting more up there in Spanish, but they're just a great resource for employers, attorneys, workers alike, because it just sets out the basic requirements of the law, and great for citations if you're looking for a quick citation to a theory of law. The division typically provides, here, I'll pull up one of them so this is the Info 20B that I mentioned earlier that sets out that minimum wage includes overtime. And you can see in the footnotes, they're heavily researched and provide citations to the supporting law, which supports the explanation within it. And so if you're writing a motion to the court or arguing a brief and you're looking for a quick cite, these infos are a great resource for those as well, because as I said, they're heavily researched and have all kinds of explanations for why what they're doing should be followed, and case law citation to the controlling cases for that theory of law. And I'm going to go back and reshare my PowerPoint with you all. So as I mentioned, I just set out some of the key changes, but the infos are constantly changing. And so it's good to keep updated, check that website every so often, because you never know when they might post a new info or make changes to an info. And they're just, quick guide for if someone asks you a question on a specific area on the Healthy Families and Workplaces Act or commissions or PTO, they're a great place to reference quick information or quick citations when you are writing motions to the court or briefing topics. Okay, so now moving on to some recent key cases that came out or had decisions issued last year. I apologize, 2 of them are my cases, but they did have some pretty drastic changes to Colorado law. The first one is IO versus Meadow Vista Assisted Living, LLC. That case went to a 5-day jury trial in November of 2022, and the court issued a determination in June of 2023. In the previous, I apologize. In the previous minimum wage orders, this case expanded and went back 6 years for unpaid minimum wage and overtime for a home health care worker who was the only employee working and staffing a house owned by a third-party facility, housing anywhere between 5 and 8 residents with dementia or elderly or other sort of needs where they were unable to live on their own and they needed bathing, medication, feeding, cleaning sort of care. And previously, this sort of there was an exemption in the minimum wage act, or the minimum wage order, that exempted certain home health care employees who worked with companions hired by a a family or within someone else's home. And the language of the previous minimum wage orders was unclear because it was a bunch of commas and semicolons all lumped together with various different exemptions that had nothing to do with each other. And there was no Colorado state case or court that interpreted the minimum wage order to see if it applied to workers who worked for third-party businesses rather than for families or people in their own private homes. And the Colorado district court has interpreted the case, and it's gone up to the 10th Circuit in 2 different cases. The first case was Jordan versus Maxim Healthcare Services, and that declared and interpreted the law to say that individuals who worked for third parties were likewise exempt from minimum wage and overtime protections. We brought this case to state that that was the improper interpretation. We filed it in Denver District Court and requested that the court interpret the law for the first time in Colorado to declare that no individuals who worked for third-party private entities were not exempt from minimum wage and overtime. And the Honorable Judge Buchanan, who is now retired, determined that he retired, unfortunately, before the case went through, but then it was passed along to Honorable Judge Luxem, and he determined that the case, the minimum wage and overtime protections should apply to people who work for private entities. And the case went back 6 years. The info that came out in February of 2023 came out before the determination was issued, and we were able to argue that our clients should be entitled to not just minimum wage, but minimum wage and the applicable overtime rate going back those 6 years. And the court declared, using that info, that that was the proper interpretation. And then one other thing to flag with that is that this case, the client worked in Denver. And so the Denver Revised Municipal Code also applied to our client's claims. The Denver Revised Municipal Code provides for expansive penalty provisions, as I mentioned earlier. And under the Wage Act, it provides for penalty provisions and not just damages. And we argued under Evans versus Loveland Auto, which interprets the dual damages provision under the FLSA and the Colorado Wage Act, that there are additional provisions within the Denver Revised Municipal Code that did not serve the same purpose as the penalty provisions of the Wage Act. And we were able to secure the treble damages under the Denver Revised Municipal Code in addition to the penalty damages under the Colorado Wage Act. And that resulted in almost $1 million judgment for our client, who had not been paid minimum wage going back 6 years by this couple who owned 3 different home health care facilities. Brennan versus Broadmoor was our client filed a case with the CDLE that was then appealed to a hearing officer within the CDLE. He was pro se throughout the CDLE, and the initial determination was that he was entitled to minimum wage and overtime and had not been paid his tips. The hearing officer reversed that determination and stated that he was not entitled to additional minimum wage because the Broadmoor paid a service charge, and the service charge was not a bona fide tip. And so the Broadmoor was permitted to take a portion of that service charge and distribute whatever remaining part to the employees because it was not actually a tip that was owned by the employees. However, the conference servers who worked at the Broadmoor were not exempt from overtime as commission sales employees, as was argued by the Broadmoor. This case was appealed to the Denver District Court and up to the Colorado Court of Appeals. And we received the determination from the Colorado Court of Appeals this July. The Colorado Court of Appeals confirmed that a conference server who sells wine to a table is not a commission sales employee and is entitled to overtime because they are essentially a server, as would be at any sort of restaurant. However, the Court of Appeals affirmed that a service charge is not a bona fide tip and expressed the need for rulemaking and legislative interpretation of tip. The division immediately registered or published the info following this decision. And so you can see how this case flags the importance of where there's gaps in the law, but then also how the CDLE a response to those gaps to once there's a key note that there's something needs to be changed or there's a need for an interpretation, and the CDLE is keeping track of those cases to offer guidance within Colorado law when there are gaps. Oops, I apologize. Hicks versus Colorado Hamburger Co. Inc. That was a class action that was filed on behalf of McDonald's workers who alleged class members alleged that they did not receive rest breaks and they did not receive paid meal breaks. And they brought a class action on behalf of all workers who worked for the McDonald's franchises owned by Colorado Hamburger Company. I believe that this case is still ongoing, but there wasn't a court issued order from the Colorado Court of Appeals definitively declaring that class representatives may use representative evidence and class-wide inferences that rest breaks were denied. Essentially, employers are required to permit employees to take 10-minute compensated rest breaks for every 4 hours worked or major portions thereof, as the law says. It essentially means that if you work 2 hours in 1 minute, you're entitled to a rest break, and for every 4-hour increment, you're entitled to an additional rest break. For the court determined that there were arguments on either side that the employees just chose not to take their rest breaks, or they took them and they chose not to clock out. And there wasn't a lot of documentation on the employer to prove that the employees did in fact receive their paid rest breaks. And the class representative stated that no, they were always denied their rest breaks. They never chose to forgo a rest break. And when there were times that they missed a clock out, the employer had the authority to go in and change those clock in, clock out times. And the court determined that for rest breaks, very few, if any, fast food workers would choose to forego a paid 10-minute rest break where they were permitted to not work and get paid. And the description and testimony from the class representatives was sufficient to bring a class action on behalf of all workers within those McDonald's restaurants, and stating that this is what was told to me and this was the policy that I was aware of was sufficient to move forward on a class-wide basis for rest breaks alone. However, the court determined that that was not enough for meal breaks. Meal breaks are not required to be paid in Colorado. An employer is required to permit an employee to take an uninterrupted 30-minute unpaid meal break. If an employee doesn't want to take their meal break, they're not required to. And so because it's unpaid, it would be an issue of going and talking to every single person every single day about why they didn't take their rest break or their meal break. Perhaps it was too busy, or they wanted to get off work earlier, or they wanted to get paid for that time. And so the court stated that you could not use representative evidence for meal break denials because it was too much of an individual question. Gomez versus JP Trucking Inc. was a Colorado Supreme Court case that was issued in May of 2023. It has long been tracking and going through different, as you can see, it was filed quite a while ago. It was interpreting the previous minimum wage orders intrastate drivers exemption. Essentially, truck drivers in Colorado who did not cross state lines, there was a question about whether or not they were exempt from the overtime provisions under the Federal Motor Carrier Act, and then within the interstate driver exemption within the minimum wage order. There have been conflicting determinations from the 10th Circuit, the Denver District Courts, and some Colorado state courts, but there has never been a clear answer on whether or not individuals who did not cross state lines driving trucks within the state of Colorado were exempt from minimum wage and overtime protections under the previous minimum wage orders. The Colorado Supreme Court finally declared that the interstate drivers were not exempt from overtime. And while it came after the minimum wage orders were no longer in effect, the key importance for Gomez is that it sets the standards for interpreting Colorado wage and hour law. It goes through an in-depth analysis of how to approach Colorado wage and hour law, because there's a tendency to turn immediately to the FLSA or the Fair Labor Standards Act. And the Colorado Supreme Court definitively declared that that is improper. The first step you must take is to look at the clear language of the law. If the law is clear, there's no need to look at anything else. Even if you know what the FLSA says, it does not matter, because the FLSA sets a floor and not a ceiling. The court then goes on, if the language is ambiguous, which it determined it was for the minimum wage order, was the next step was to look to see the intent of the drafters, or if there was any sort of law that was similar that could be used as guidance for interpretation. The Supreme Court stated that they compared the language of the minimum wage order and the FLSA and stated that the language was too dissimilar in order to turn to the FLSA and use that as an interpretive method. Because the language was too different and not identical enough. Essentially, the court said if the language was identical, then that was an intent to follow the FLSA. However, if there were deviations in the language, then that was intent of the drafters to provide different protections than what was under the FLSA. The court then turned to and used interpretive bulletins or interpretive notices issued by the Division of Labor Standards and Statistics to interpret the minimum wage order. So that's just can also be used as a citation to enforcing or saying that the validity of the infos published by the CDLE are useful for interpreting Colorado law, because it sets out the division's intent when it is drafting the now comps order. It can also it has some great citations to other interpretations of Colorado law and goes beyond interpreting the minimum wage order or interpreting this specific exemption, because it sets out just the broad framework for going about and interpreting Colorado law. And finally, at the bottom, I have Perez versus By the Rockies. It's a Colorado Court of Appeals case that I believe was issued in November of 2023. It definitively declared that there is a 6-year statute of limitations on minimum wage claims under the Colorado Minimum Wage Act. This has long been a litigated issue in both the U.S. District Court and in state courts. However, there's never been a definitive decision about how to interpret the statute of limitations for the Colorado Minimum Wage Act, because there is no explicit language that sets the statute of limitations is X in the Minimum Wage Act. However, the Colorado Court of Appeals has definitively declared that even though it does not explicitly state that there is a 6-year statute of limitations, the Colorado Minimum Wage Act is clear that the 6-year statute of limitations applies. And so going back to that info on time worked, and going back to Gomez Trucking and IO, for these cases that are interpreting exemptions from minimum wage and under the minimum wage order, with this clear declaration, there are now people who maybe thought that they didn't have a claim, but they still can go back 6 years from today's date to claim any unpaid minimum wages that were previously denied, perhaps under a previous interpretation of the law that has since been clarified. Okay, and so now on to not so new, but still important. It has long been a provision of the Colorado Wage Act that employee cannot waive their rights under the Colorado Wage Act. It is clear in 8-4-121 that employee cannot waive that right through writing or oral agreement or in any other way. So if an employee says, it's fine, you don't have to pay me at all, and they say that in writing, that is not a valid defense to failure to pay minimum wage to an employee who is entitled to minimum wage. And it expands beyond just minimum wage. It expands to all areas that are protected under the Colorado Wage Act. And so that is a key citation that I'm constantly using, and it is often many employers are unaware of it as well. And so employers tend to enter into contracts with their employees, which they think are valid, but may be unaware of this right. And so if you're representing employers as well, it's important for them to know that they cannot enter into a contract that would waive an employee's rights because they could be opening themselves up to liability. And then under below we have Leonard versus McMorris. It was overturned by legislative action in 2019, effective January 1st of 2021. Previously, under Leonard versus McMorris is I believe, a Supreme Court case, stated that individual shareholders, supervisors could not be held individually liable for the unpaid wages of an employee without piercing the corporate veil. Piercing the corporate veil is a multi-pronged test that is very difficult to get over to prove that somebody should be held individually liable for the unpaid wages of the employee of the corporation or company. However, through House Bill 19-1267, the legislature changed the language and definition of employer in the Colorado Wage Act, and to definitively declare that employers can be held individually liable for the acts of the company. This doesn't necessarily have to be an owner. It could be a supervisor. It could be a shareholder. It could be anybody who has enough control over the business to that they became effectively responsible for choosing whether or not to deny pay to an employee. There is an info that sets out all those various factors for determining whether or not somebody could be held individually liable. But under this House bill, it is much easier now. You do not have to go through the steps of piercing the corporate veil to hold an individual owner, supervisor, or shareholder responsible for the unpaid wages of an employee. We are seeing that Leonard versus McMorris is still being argued as good law, but the legislature declared that it is no longer good law as of January 1st of 2020. So if you have a minimum wage claim going back 6 years, then yes, if you wanted to hold an individual liable, you would have to go through the practice of piercing the corporate veil. But for all wages owed after January 1st of 2020, you no longer have to take the steps to pierce the corporate veil in order to hold and allege that an individual should be liable. This is also another great resource we're finding in bankruptcy, especially after 2020 and COVID. Many entities did not make it through COVID and filed for bankruptcy. However, the individual owners did not individually file for bankruptcy. And this is a method for securing unpaid wages for those workers who were laid off in 2020 or 2021 as a result of COVID and were never paid their wages because the entity filed for bankruptcy. It does not matter if the entity files for bankruptcy, if an individual meets the qualifications under the multi-factor test to be held individually liable, they can be held responsible for the wages, regardless of whether or not the entity has secured a bankruptcy or is in the process of bankruptcy. One key thing I mentioned with the comps order that came into effect on March 16th of 2020, at the very end of it in Rule 7.4.1, there is a major provision that states that an employer shall be ineligible for any employee-specific credits, deductions, or exemptions in the comps order if they fail to post the comps order in a place that is frequented by employees, or if that is impractical, failing to provide a copy to employees, which essentially means that if you have an employee who is, say, an outside salesperson who is exempt from overtime, but the employer fails to take the simple step of posting the comps order poster in the office or providing a copy via email to the employee upon hire, then they are ineligible for that overtime exemption. And an employee who, even if they think that they're exempt from overtime, may have a claim for overtime. It is a simple act that has a lot of power. And in the IO case that I mentioned before, it was very clear the employer admitted that he took no steps to post the poster or provide a copy to our client. And so for all unpaid wage claims after, all unpaid overtime claims after March 16th of 2020, there was no argument for the employer because this rule declared that basic failure to do so made him ineligible for those deductions or for those credits and exemptions. One final thing, it is an employer's burden to prove that an exemption for minimum wage or overtime applies to an employee. It's a old case from the Colorado Court of Appeals that I'm constantly using because sometimes employees just do not have the information, and it is a key thing that it is the employer's burden to show it, and it is an employer's burden to prove that an exemption applies. They cannot simply state that an employee is exempt. They must take the steps to prove that they are exempt. And this is a great citation that I'm constantly using in most of my cases. And okay, well, I apologize if I was speaking very fast. Does anybody here have any questions? I'm not seeing any questions in the chat or hands raised, so I'm assuming that means that nobody has any questions.
It looks to be the case. This is Kyle, and I can again, Victoria is happy to answer any questions that come in after the fact. So if anyone has anything they want to route through me or send directly to her, she's always happy to answer those questions. But yeah, if we'll give it another call, but then if no one has any questions, we can call it a lunch. Sometimes people need some extra time to think about it. So they'll think of a really good question in about 10 minutes, I guarantee.
And like I said, I'm happy to answer questions. If you could not already tell, I geek out about this stuff. I very much like to talk wage and hour law, and so if you ever want to talk about it, I'm happy to. And for those of you, if you are interested in practicing employment law or already are and you are not aware, PELA, it's an organization that's the Plaintiff Employment Lawyers Association in Colorado. It's for attorneys who, I believe, 75% of their practice is toward representing employees, and it's a great resource to join if you're looking to get into the area or you already in the area and you just would like some help. There's a listserv and we have a retreat, and everybody also geeks out about employment law and is always happy to answer any question, no matter how silly you think it might be, because usually people on the listserv typically also have those questions as well.
Yeah, I see it. Thank you for the great presentation and info. So I think we can probably call it at that point. So thank you again, Victoria Guzman. There's some more thanks coming in. Again, to everyone, I will get the recording up as soon as possible and send that information out along with the PowerPoint from Victoria. I'm still waiting on the CLE form. I know they're a little backed up here. I'll get that to everyone hopefully before the end of the week at the latest. And I'll also get the presentation posted to our YouTube channel. We do have an employment law section lunch coming up in March. I'll get everyone that date as soon as I have it. But again, for now, thank you again to Victoria Guzman for presenting today. And thank you for everyone for joining us. Thanks,
Yes,
everyone.
thank you. Thanks for having me.
Have a good afternoon. Bye.
Bye.